Thank you for that speech, Topical. And now I'd like to, if you will, present Professor Spencer to give the opposing view. There are always two sides to every story. Also, Professor Spencer.
Thank you. I suspect that I'm a lion come into a den of Daniels. But I'm not going to apologise for being part of the Corpus Juris project. I'm not going to say that I don't think it's necessary, and I'm not going to say that I don't think we thought it out properly. I'm proud of what I've done as part of it, and I value the time that I've spent involved in it. But I have to say that Mr. Erikson has grossly misrepresented, first of all, the state of affairs with how far the EU has got with it. It's never been more than a discussion document put together by a group of academics who were asked to think about the problem of prosecuting for European budgetary fraud and told, think up a solution which might work if there were the political will to implement it. It was never devised by those of us who put it together or by those of us who asked to do it for any purpose other than prosecutions for budgetary fraud, and it certainly hasn't been officially adopted by them in any shape or form. It's not been officially adopted by the Council. It's not even got the official backing of UCLAF, the European Community's official anti-fraud body. The stage it's got to is that the European Parliament expressed interest in it and wanted to know more about it and asked the people who wrote it, ultimately, to conduct a further study about the feasibility and acceptability of it, with a view to producing a further report, and at the moment I have the honour to be working on this further report. So there's no question of the European Union in any official state, in any official manifestation, having publicly adopted it. It certainly hasn't. Secondly, I don't think there's any question of the proposal being enacted by way of directive under Article 280. My view, and the view of a number of the other people on the Corpus team, is that the Corpus could only be brought about by probably amending the European treaties, or conceivably as a result of a third pillar convention if it were adopted by all the other member states. So there's no question of this being about to be forced upon us by way of a directive, and if there were any attempt to do so, it's sufficiently controversial that I'm quite sure the directive would be challenged before the European Court of Justice, and if I were a betting man, my bet would be that the European Court of Justice would say that it can't proceed under Article 280. Yes, of course, there are people who would like to see this as being, if they're pro a bigger and better European Union, the first step to something else, or who fear it might be a slippery slope down which we might slide. But of course, it doesn't have to be. It could only be extended if there were an agreement to extend it, and you only have to look at the first sections of this to see that it isn't a code of criminal law or criminal procedure for all purposes. The part on substantive law at the beginning is simply and solely about offences of budgetary fraud relating to the European budget. The debate tonight is about whether the motion is about to be as to whether this involves a derogation from national sovereignty or a dent on civil liberties. As regards derogation from national authority, I'm not even going to pretend that it doesn't, to some degree. Yes, of course it does, because the European Public Prosecutor, if we had one, would have the right to control what cases were prosecuted before the courts in the member states in the area of budgetary fraud, whereas at the moment the Attorney General in England and the Lord Advocate in Scotland has the power to veto prosecutions, and the Home Secretary also has power to say what help our courts give to courts in other countries. and in the area of European budgetary fraud that wouldn't apply, and I'd be the first to accept that within the area of prosecuting for offences of budgetary fraud, that would be something of surrender of a bit of national authority. And as far as I'm concerned, the question is whether it's necessary and desirable rather than whether it's in principle one at all, which of course it is. I think it's only a small one. Of course, it could be taken as the model for something bigger, and but if it were taken, it could only become the model for something bigger if there were political will to extend it to something else, and it could only be extended to something else if further decisions were made, and the legal basis under which it could be done would have to be different from the legal basis upon which it might possibly be done in the case of a code of criminal law, criminal procedure for offences of budgetary fraud. The government at the moment has not taken any official position in relation to the Corpus project either. There's a House of Lords Committee on Europe which has decided the Corpus would be a good subject to investigate, and last week I had the honour to give evidence to this committee together with Madame Delmas-Marty, who chaired the committee of people who drafted it. I've seen the submissions from various official bodies to this, including one from the Home Office, and the Home Office submission is that overall they don't like it, but nevertheless they think it contains a number of elements which ought to be thought about further. And they take it seriously, but though they don't like it altogether, they don't think that it's completely appalling or dreadful or contains nothing in it that's of any use. Turning to the content of the corpus itself, I think Mr. Erikson has misrepresented, in a serious matter, the powers of the European Public Prosecutor and how much of a threat these are to civil liberties. Of course, it's true that in some continental jurisdictions, one and the same person has the job of both investigating offences and deciding who stays in prison while the offence is being investigated. That's the model in France with the juge d'instruction. It's the model in the Netherlands with the rechtercommissaris. It's the model in Belgium with either a juge d'instruction or a rechtercommissaris, depending on whether you're in the French or the Dutch-speaking part of it. But it's certainly not part of the Corpus Juris proposal that the public prosecutor would decide who stays in prison pending the case being investigated or tried. Much sport has been made of this character called that we called in the corpus the judge of liberties. This person is put in the corpus in order to require the countries in Europe who don't have a separate judge who has to decide questions of remand in custody from the judicial figure who investigates to have one. It's an export of the common law idea of having a separate judge who has to authorize coercive measures in evidence gathering and, of course, even more coercive measures like remanding in custody. And there's no question whatever of the European Public Prosecutor having the right to tell the judge who would have to give permission, as happens in English criminal procedure at the moment, that he had to stay in prison or how long he had to stay in prison. It might interest you to know that Madame Delmas-Marty, who chaired this committee, actually chaired a committee in France earlier on the reform of French criminal procedure, which recommended the abolition of the juge d'instruction in France on the ground that it was wrong for one person to combine in one pair of hands decisions about investigating cases and keeping people in custody. And it's certainly not part of the scheme, nor, I think, even capable of being reasonably considered as part of the scheme, that the European Public Prosecutor would be able to throw people into custody there to rot for ages without any investigation before a court about the legality of the detention. As to jury trial, we quite unashamedly recommended as one of the proposals, that offences against budgetary fraud should be tried before courts that didn't have juries. It's true that this proposal was made from the common law was made by the Roscoe Committee on Fraud Trials in 1985 or 6. But incidentally, you may or may not know that the Home Office is at the moment considering this again and has a consultation paper, the consequences of which it's at the moment digesting about whether we should have non-jury trials or maybe amended juries dealing with complex fraud cases. The argument against having juries in complex frauds is that they aren't the safeguard which they're supposed to be, because unfortunately it sometimes happens that jurors are not able to understand the details of a complex fraud. Furthermore, on the continent of Europe, juries certainly aren't regarded as the safeguard of civil liberties that we regard them here. The French introduced them after the Great Revolution and then saw them consigned to the guillotine in France, about 17,000 people in jury courts at the time of the Revolutionary Terror. And although Lord Devlin said in his book that jury trial is the lamp by which freedom lives, and with the implication that you can't have a democratic country without them, I'm interested to see that the Netherlands got rid of jury trial when they kicked the French out, because they regarded it as a French innovation and an invasion on their traditional legal scene. And I think in practical terms there are few more democratic or liberal countries than the Netherlands. Furthermore, if the corpus came about and if there were enacted as part of the corpus a rule that budgetary fraud offences had to be tried without juries, I fail to see how that's the end of jury trial, given that budgetary fraud offences are only a small number of offences. On the subject of inquisitorial prosecutors, it's also, which of course we recommend the European Public Prosecutor being somebody who combines investigative powers and also the duty to conduct the prosecution. It's wrong to imagine that that's an innovation in the common law scene, because in 1987 we introduced the Serious Fraud Office, and the director of the Serious Fraud Office is the original inquisitorial prosecutor, having the duty to investigate and the power to ask questions and the power even to require questions to be answered by the suspect in the case on pain of fine if he doesn't answer. And if you go back further than that, Customs and Excise are the body which at present investigate most budgetary frauds in this country, and the Customs and Excise have the most extraordinary inquisitorial powers, including the powers to require questions, and, even more astonishingly, even the power to override the Home Secretary and order the release of somebody who's been convicted of a budgetary fraud if they think that would be a good idea afterwards. I don't like either of those very much, and I would add that the powers that the Serious Fraud Office has at the moment and Customs and Excise have at the moment go considerably beyond the powers of investigation that we proposed for the European Public Prosecutor, and we've been criticised in this country by some people on the ground that the inquisitorial powers we propose are too soft, and they don't do what some of the inquisitorial powers that our own national prosecutors in fraud cases have at the moment. We're asked to consider whether the Corpus Juris would be an unacceptable threat to civil liberties. I concede that it's a derogation, I think to a small extent, from national sovereignty, but I completely decline to accept that it's a derogation from civil liberties. The defence rights in the Corpus Juris project are well safeguarded. It's provided that the defence enjoy all the rights guaranteed by the European Convention on Human Rights, including the right to silence, actually a right to silence wider than they have in English law at the moment if somebody's being prosecuted by the Serious Fraud Office, and something else they don't have in this country, an automatic exclusion of illegally obtained evidence, whereas in this country, if evidence is illegally obtained, the court has a discretion as to whether or not to admit it. Mr. Erikson said he didn't think anybody in this country had come forward to defend the Corpus Juris, and I was a rara avis in terra, being prepared to come forward and say anything in favour of it. Well, I'll tell you one body which has publicly backed the Corpus Juris, and that's an organisation called the Fair Trials Abroad, which is a defence organisation, the energies of which are devoted to helping Britons who are being prosecuted in the continental legal systems, and foreigners and legal systems anywhere in the world, and also helping foreigners who are being prosecuted before our courts. And their angle on the matter is the following, that all the problems prosecutors have prosecuting people in transnational cases are reproduced, only worse, if a case actually starts to be prosecuted and there's a defendant, and is that if a foreigner is before a court, the court is always very reluctant to grant that foreigner bail because they're afraid that he'll run away and there isn't any legal machinery other than extradition by which that person can be got back again. So foreigners tend to stay in prison pending trial, whereas nationals of the country don't. Secondly, there are no legal means at the moment by which the defendant who's in one country can conveniently from the country next door, which he might need for his defence, because the courts in England have no power to compel evidence from the courts in another country. The witnesses have to be in another country. We may or we may not like increasing movement and increasing doing business with the rest of Europe, but inevitably it's had the consequence that far more foreign nationals are being caught up in the legal systems of the other member states than was ever the case before. And one of the consequences is that the number of people in the European Union who are at present remanded in custody in the different courts of the member states has gone up from a few hundreds to a good many thousands. And the Fair Trial Abroad angle on the idea of a common European criminal justice system is that it's essential in order to safeguard the defence rights of defendants in a country where far more defendants are actually facing trial outside the countries of which they're the nationals. So, I completely reject the argument that the Corpus Juris involves a threat to civil liberties, although, as I say, I'm quite prepared to concede that to some extent it involves a dent on national sovereignty. Thank you.
I would like to thank, on behalf of us all, Professor Spencer for his candour in defending what is apparently indefensible